Hi, Tony DeWitt here, Missouri appellate attorney and the guy who likes to make the law make sense on YouTube. Today we have two cases from the 10th Circuit Court of Appeals that demonstrate why it's a bad idea to be a pro se plaintiff. So let's get into that. So the first of our cases here is U.S. versus $422,268 in United States currency. The money is the defendant. So how do you get to the point where the government is suing money? Well, this is what we call civil forfeiture. During a drug trafficking investigation, Colorado state troopers found $422,268 in Guillermo Valdez's truck and seized it. The government then filed this action seeking forfeiture of the money, and Mr. Valdez filed a claim contesting that forfeiture, but then disappeared, filing nothing for months and failing to appear for court proceedings. After several fruitless attempts to allow Mr. Valdez to pursue his claim, the district court struck the claim and ultimately entered judgment for the government. Valdez appeals, but his brief fails entirely to address the district court's decision, and it amounts to a waiver of a challenge to the decision, and so we affirm. So then they get into the background. Said Valdez and another man had delivered cocaine to a buyer near Denver and received cash for the drugs. That's what the investigators suspected. Investigators later worked with Colorado state troopers to pull over Valdez's truck. The troopers searched the truck and found a total of $422,268, some of it wrapped in cellophane and electrical tape, and the rest of it in vacuum-sealed bags. The government sought forfeiture of the money, alleging it had been furnished in exchange for a controlled substance. Gosh, I wonder why anybody would think about money being transported in vacuum-sealed bags as being, associated with transporting controlled substances. Why would you ever carry a wallet when you can get your money hermetically sealed in a food saver bag? But I digress. Mr. Valdez contested the forfeiture in a letter he wrote from the county jail. He asserted the money was his, quote, retirement. Sometimes this stuff just makes me laugh. The magistrate judge entered a minute order stating that Mr. Valdez's concerns would be addressed at an upcoming status conference, but then Mr. Valdez did not appear. So they made additional efforts to contact him, and again, Mr. Valdez did not appear at the rescheduled conference. So then they sent him a bunch of stuff, both to the jail and to his last known address, and it ordered him to update his contact information, warned him that failure to comply would result in dismissal, and Mr. Valdez neither updated his address nor appeared at the show cause hearing. The magistrate judge recommended the district court strike Mr. Valdez's claim for failure to prosecute, and that's what happened. The magistrate recommended dismissal, the district court adopted the recommendation, and later entered judgment on forfeiture to the government. Because Valdez represents himself, we construe his filings liberally and hold them to a less stringent standard than we would if a lawyer had drafted them. But our liberal construction can only go so far. We cannot, for example, construct arguments from Mr. Valdez that he himself attempted not to make. So let me explain that. Judges are supposed to be umpires. They're supposed to call balls and strikes. They're not allowed to run up to the mound, lazily throw the ball toward the catcher, zip behind the catcher, and say, oh, okay, that's a strike. They can't do that. What they have to do is they have to take it as it comes. And if you don't make the right arguments based on the law, you're going to lose every time. And that's what happened to him here. Valdez's opening brief requires us to conclude that he's waived any argument against the district court's decision to strike his claim. His arguments appear to focus instead on the merits of his claim, but it wasn't struck because of the merits. It was struck because he failed to prosecute it, and for that reason, the district court's order was affirmed. Hey, allow me to interrupt for just a second and ask you, if you haven't already subscribed, please subscribe. And if you wouldn't mind, hit that like button. That lets YouTube know that this is a good video and they can recommend it to others. It helps me out a lot. Thanks. Next, we have Mr. Cerna versus David Webster and Margette Webster. and this is an order and judgment from the 10th Circuit. Pro se plaintiff Mike Cerna appeals the district court's order dismissing with prejudice his federal claims and declining to exercise supplemental jurisdiction over his state law claims, exercising jurisdiction over 28 U.S.C. 1291, which is the statute that gives the circuit courts of appeal jurisdiction over appeals from district courts' final orders or judgments. I briefly need to explain the jurisdictional issues here. He filed a claim under 42 U.S.C. Section 1983 for deprivation of his civil rights, which is a federal claim, and the federal court has jurisdiction over that, assuming that you actually invoke that jurisdiction and you have facts to support your claim. However, if you file state law claims, then the court can exercise supplemental jurisdiction, meaning it can deal with these supplemental claims as part and parcel of the case that it's deciding. But if it doesn't have federal jurisdiction, or if it dismisses the federal claims, it has to dismiss the supplemental claims because there's no basis then for the federal court to make a ruling. The issue here is Mr. Cerna is upset about a state court judgment that evicted him from his house, and he's upset because he lost. And so his remedy, he thinks, is to go into federal court and complain about it there. This isn't going to work out well for him. Mr. Cerna's amended complaint alleges violations to federal statutes that do not provide for private causes of action and fails to allege facts necessary to maintain causes of action under 42 U.S.C. Sections 1983 and 1985. And Mr. Cerna's brief on appeal advances no legal argument for why the reasoning that the district court relied on in dismissing his federal and state claims was erroneous. Now, here's where we can sort of read a few of the tea leaves. This guy is going to go after the people who evicted him from his house in a foreclosure action. And in a foreclosure action, of course, you know that what you've got is somebody who took out a mortgage, didn't pay the mortgage. In this case, the private individuals who held the mortgage foreclosed on it and evicted him from his property. Reading through the tea leaves, what you get here is that some of these things that he's arguing are very, very close to a lot of the claims that sovereign citizens make when they argue these kinds of issues in front of district courts and state courts throughout the country. And I will hopefully provide a little bit better information on why these claims just don't work. So the case has a long procedural history. The first one, he filed a lawsuit after he lost his home in a state court foreclosure action, and he sued the Websters for conspiring to wrongfully evict him. In the first of these cases, Cerna won. The magistrate judge found the complaint failed to state 4th and 14th Amendment claims and recommended dismissing the action, which the district court did. The present case, Cerna 2, follows much the same script. Mr. Cerna filed suit advancing similar allegations against the Websters. Another magistrate judge, meaning a different one, observed that the complaint lacked adequate facts to establish federal jurisdiction and ordered Mr. Cerna to demonstrate the court's jurisdiction. And, because of the disposition in Cerna 1, the magistrate judge also ordered Mr. Cerna to explain why res judicata principles did not bar his federal claims on property possession. Now, res judicata is a Latin term. It means the thing has been decided. So when you bring a claim, for example, for wrongful eviction in this case, and the federal court says, no, you lose, and you've tried it through on the merits, then it's barred. You can't go back and relitigate it. You don't get multiple bites at the apple. Once you go through the judicial process, once you get a judgment, we're done. Unless you later on get an appellate reversal, the thing is a done deal, and you don't get to come back and say, hey, I'd like another bite at that apple. Yet, in spite of that, and in spite of people being told that numerous times, a lot of times they just keep on filing claims that are blatantly frivolous, as this claim is. So instead of doing what he was asked to do, which is demonstrate why the court had jurisdiction, he responded by amending his complaint, incorporating various federal law claims, and introducing other state law claims, but he failed to address the court's res judicata concerns. So the district court dismissed Mr. Cerna's complaint sua sponte under the Federal Rules of Civil Procedure 12b-6. Whenever somebody says something is done sua sponte, it means on the court's own motion. Normally, to get a court to do something, you got to stand up and raise your hand and say, Judge, I move to dismiss this complaint. And the other guy says, Judge, I don't want you to dismiss the complaint. There's an argument, and then the court says, okay, I'm dismissing the complaint. But in a situation like this, where you just ignore what the court told you to do, the court can, on its own motion, dismiss your complaint, and that's what happened here. He now appeals the district court's dismissal. To survive dismissal, he's got to, basically plead a plausible case based on facts. He can't get by with just a sheer possibility that somebody acted unlawfully. He has to set it out in factual statements that establish that he has a right to a judgment. Mr. Cerna proceeds pro se, so we liberally construe his arguments, but we can't take responsibility for serving as his attorney in constructing arguments and searching the record. And that's very much like what happened with Mr. Valdez. Applying the foregoing principles, Mr. Cerna's appeal ends where it began. He fails to challenge the basis of the dismissal, very much like Valdez. That said, the court properly dismissed Cerna's claim for 3 good reasons. First, the district court correctly concluded that Mr. Cerna's claims under 18 U.S.C. sections 241, 242, 371, 471, and 1324C failed to state valid claims. Okay, here is 18 U.S. Code section 241, conspiracy against rights. If 2 or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having exercised the same, and it goes on, and it says, they shall be fined under this title or imprisoned for not more than 10 years or both, and if death results from the acts committed in violation of this, and it goes on. Nowhere in this statute at any point does it say you can sue if somebody violates these rights. And if you have a penal statute like this one is, and it doesn't give you the right to prosecute an action on your own, well then, you're out of luck. I'll give you a good example of a statute that does, the RICO statute. The RICO statute says you can prosecute a claim against someone for a racketeer-influenced corrupt organization that, for whatever reason, took your money or injured your property in some way. And this is Section 371, conspiracy to commit offense or defraud the United States. If 2 or more persons conspire to commit any offense against the United States, well, again, if there was an offense committed, it would have been committed against Cerna and not against the United States. So this statute doesn't even apply, but perhaps even more importantly, it also doesn't include any kind of private right of action. And when we get up here to Section 1324C, well, you can look all the way through the Title 18, which is the Criminal Code, and you will not find Section 1324C anywhere. That's because it doesn't exist. Now, the court gave the guy a little bit of credit and said, well, maybe he meant 8 U.S.C. 1324, but even that wouldn't apply. And so these statutes don't provide for a private right of action, so they are not enforceable through a civil action. A plaintiff cannot recover civil damages for an alleged violation of a criminal statute. And again, it mentions here that there is no private right of action and that there is no Section 1324. So because these things do not exist, one of them doesn't exist and the others do not have any private right of action, an amendment wouldn't cure that legal defect, so the court properly dismissed the claim. Second, the district court correctly concluded Mr. Cerna's claims under 42 U.S.C. 1983 and 85 didn't contain sufficient factual matter, except it is true that would state a claim. The complaint alleged the Websters evicted him with the use of deputies, despite a right existing for him to reside at the property of the irrevocable trust. And again, when you start getting into these things about a right to irrevocable trusts and that sort of thing, it starts to sound a lot like the sovereign citizen playbook. And in this case, this guy appears to be a bit pig-headed about this because he continues to go after the Websters. And keep in mind, every time he sues the Websters have to hire an attorney and go to court and defend themselves. And so they're incurring a lot of costs in this too. And of course, they say, when a private person invokes the aid of a state to seize property from somebody, the private person doesn't act under color of state law. So 42 U.S.C. section 1983 and 85 would not apply. So because the complaint neither alleged that state law applied was unconstitutional or alleged the Websters conspired with state personnel to seize the property, the district court properly dismissed Cerna's claims. Again, this is a problem with him stating what's wrong and not understanding the law. It also says, so because the complaint neither alleged the state law applied was unconstitutional, nor alleged the Websters conspired with state personnel to seize the property, the district court properly dismissed Cerna's 1983 claim. On appeal, he adds a bunch of facts that weren't in the original complaint, but, as the court notes, they can only consider the facts alleged in the amended complaint, and they don't consider allegations that are newly made on appeal. Mr. Cerna basically asserts the Websters hired the sheriff's department to collect the property without a judgment and hired the deputies a second time to evict him. Again, Cerna did not allege the state law being applied was unconstitutional or that the Websters conspired with state personnel to seize property, nor did he allege any racial or otherwise class-based discriminatory animus behind the action being taken. Dismissal was thus appropriate. Third, and finally, the district court properly declined to exercise its discretion to issue a declaratory injunction because what he asked for was a ruling that the state court judge erred in his ruling and asking the court to undo the foreclosure sale. But a federal district court does not have subject matter jurisdiction to review a case that was resolved by state courts. Only a state appellate court can do that, and so the district court properly declined to entertain the request appropriately at that time and dismissed the complaint. Now, what this actually means is this. If you have a complaint, if you have the need to go after someone in federal court, you really need to hire a lawyer. The rules are meant to be followed. If you don't follow them, you lose, and you can't expect an appellate court to rescue you if you don't follow the rules in the district court. That's basically it. If you have the opportunity today, please try to go out of your way and do something nice or kind for someone. Perhaps donate to a charitable institution. We were told this week that the food pantry is in desperate need of peanut butter. So we went the other day to the store and got 2 big jars of peanut butter and dropped that in the basket for the food pantry up by our post office. All they had was the extra crunchy Jif at Sam's, so that's what they got. But they also got some Idahoan ranch mashed potatoes, which we didn't particularly care for, and some canned roast beef that we got from Costco that was, well, let's just say you wouldn't need any teeth to eat it. It was overcooked in the extreme. But it would be good to make something like barbecued beef sandwiches for people who were really hungry. So it's protein, and we stuck it in there. I think it's really important to remember that there are a lot of people who go hungry every night, and anything we can do to mitigate that is a good thing. Have a great day today, a better day tomorrow, and catch me down here then next time at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.